States, or people who want to engage in business in the United States and are looking for options that will allow them to come to the United States, be admitted by immigration to perform their specific purpose. And so when I was first thinking about this presentation, for new entrepreneurs or for investors in new enterprises, unfortunately, our system of law right now does not adequately address the needs of entrepreneurs. And in thinking about it, it was very difficult to come up with a traditional presentation of this is what you do. So I thought what I would do is I would give you an idea of what it is that I do when I'm dealing with different kinds of individuals who are trying to accomplish a business purpose, and how I use some of the existing forms and try to fit people in. Now, fortunately, about 2 weeks ago, the federal government published what's called a proposed rule. And a proposed rule is a proposed regulation where the government's saying, we plan to implement this regulation. And it deals with immigration option for entrepreneurs, recognizing what I just said, that our system just doesn't adequately address it. And so right now that's going through a comment period, which is the normal way of enacting regulations. They publish it, they say this is what we're planning to do, and people have an opportunity to comment. And the comment period goes through October. If after the presentation anyone here or there wants information on how to submit comments, you'll be able to get my email. It's listed on the brochures or through Rocket Lounge. And I'll send you information on how to make comments. Now, it's important to understand in U.S. immigration the different ways that you can come to the United States, okay? And basically, most people, you're familiar, you get on the airplane and you fly to the United States, and when you get there, you see a customs officer, okay? And that person will ask for your visa, they'll look, ask you questions, and then they determine whether you come in or not. And a lot of people are not aware of that. If you have a visa, that's not a guarantee that you're going to get into the country. It's kind of like a pre-approved credit card. That's how I think about it. Sometimes you get a pre-approved credit card offer and you have no need for a credit card. You say, that's the last thing I need. So you chuck it to the side, but you don't throw it away. Well, let's say a few months later, you find out you have some very serious disease. And now you're gonna be off work, and the medical bills start building up, and all of a sudden you find yourself, you have to file for bankruptcy. And you say, well, I'm gonna file for bankruptcy, but I'm not gonna have credit, how am I gonna go on with my life? And you say, well, wait a minute, I got that pre-approved credit card offer. I'll fill it in now. So if you send that pre-approved credit card offer, what do you think happens?
Probably it's not gonna be approved.
You get denied. And you'll get a letter saying, hey, the pre-approved credit card offer was conditioned on, and if you read the small writing, it says the conditions when we pre-approved you. Conditions have changed. So a visa is the same way. A visa basically is telling the inspector that a consular officer who gave you the visa has made the determination that at that time you met the criteria for that visa. The immigration officer could determine that the consular officer made a mistake or that you had an immigration bankruptcy. Something changed, and therefore you can't do it, okay? So the process to come to the United States usually involves coming in and being admitted. So the officer looks at your visa, decides he's gonna let you in, and you're admitted. The moment you're admitted, you obtain what's called status, a type of immigration status. So whatever visa I have, that's the status I'm gonna have. If I'm coming as a visitor, I'm gonna have status as a visitor. Each status has corresponding rules and privileges that you can enjoy while you're here. So a simple example, a visitor, there's visitors for pleasure, there's visitors for business. Business visitors can't per se work in the US, but they can pursue business opportunities, they can come to conferences. In some cases, they can come from abroad to service a client in the US if they're being paid by the company abroad and all they're coming is to provide that service. And we can go on and on, okay? Students have different privileges. they have to go to school full-time, they can only work under limited circumstances, okay, and that's it. A visitor for pleasure, they can go to Disneyland, they can visit family, but they can't work. And so those individuals that are coming to the US for a temporary purpose, the law calls them non-immigrants. They're non-immigrants. So a non-immigrant has two things in common. One, the person has a limited purpose, according to the visa. That's what we just talked about. The other is they have a limited time to do it, okay? So if I'm a visitor for pleasure, I can come here, do Disney, family, boom, 6 months, I gotta go. If I'm a visitor for business, I can go to a conference, a trade show, I can meet with potential investors, I can pursue clients, those type of things, but I have 3 months, then I have to go, okay? So, if I'm a student, I can be here as long as I'm gonna go to school, okay? If I'm a worker, so a very common non-immigrant visa is what they call an H-1B. A lot of people will be familiar with an H-1B. That's for specialty occupations. Occupations that generally require a college degree as minimum entry into the position, and the person is qualified to do that job. So that person would only have the ability to work for that one employer. So each category has the rules and privileges, okay, after admission. So a visa, therefore, is different than status. A visa is permission to travel. When you're admitted, you then have status, okay? And the status depends on the type of visa, okay? So, a lot of people may come to the US in one status and pursue another status, okay? And I want you to understand this dynamic because this is how most entrepreneurs end up dealing with the immigration system. So I come as a visitor, and while I'm as a visitor, I find an employment opportunity. And so, but I can't work on my status. So I now need to change my status to something else. And under certain circumstances, you can apply for a change of status. Okay? One exception to that applies to Europeans, and not only to Europeans, but a lot of European nations, which are those nations that have what's called the visa waiver program. So you're from a certain country, there's a treaty between the US and your country that for purposes of pleasure, business, or personal, we're not gonna require a visa. All you have to have is a passport, and in the US, you gotta do the ESTA, and then you travel to the US. Well, those individuals, in exchange for not having to go through the process of getting a visa, surrender certain options that somebody with a visa would have. For example, applying for a change of status. So if I came with a visa waiver, and I'm here as a visitor for business, and I find an opportunity that would qualify me for another visa status that I could apply for, I'm gonna have to go back home, apply for the visa, and then come back. If I had a visa, I may be able to apply for a change of status and not leave, okay? Now, that also depends on the opportunity, right? If it's an opportunity that's gonna require you to travel a lot, it doesn't really matter. Because if you get a change of status and then you leave, you always have to get a visa before you come back. So, my job is to identify what your short-term and your long-term plan is, and how to facilitate each one, keeping the big picture in mind for the end. Okay. So, with people who if we're going to define an entrepreneur as someone who is investing some type of equity in an enterprise, and they are involved in the management of that enterprise, that's usually people have different definitions for different things, but we could generally all agree that an entrepreneur has skin in the game and has expertise that they're bringing to the table, okay? So, if you look at that, and we look at, and for those who have the brochure, and we may be able to make it available electronically for people who are interested.
Actually, what I can do is I can scan it in,
Okay.
and then I can attach it to
Okay.
when we post this.
So, in there you will see, it talks about business and employment-based immigrant visas. And then at the bottom, business and employment-based non-immigrant visas, right? Remember, I was talking about non-immigrants. So immigrants and non-immigrants are different. We haven't spoken about immigrants yet. But if you go to business and employment-based non-immigrants, it gives you some ideas of some of the categories that immigration law currently allows for. So, each E1, E2. So that's generally investors or companies engaged in international trade that have a treaty between the US and their country that allows for that visa. So that visa is investment or trade driven. So the question is not what is your idea, the question is not so much exactly are you an entrepreneur, what chances of success do you have. The question is really, are you going to make a substantial investment in the case of an E2, or are you going to be engaging in substantial trade, an E1? So, what happens with an entrepreneur? And here's the problem with a lot of them will use the E2. So, the E2 requires that the individual be making a substantial investment in the United States that is not marginal, okay? So, what is substantial? The law doesn't define substantial, but basically substantial means just enough to make the business viable. So it depends on the type of business. If I'm going to start a restaurant, I make $100,000, maybe a substantial investment. If I'm going to start a gasoline station convenience store, $100,000 is not going to be enough. I'm going to need at least $500,000. So based on the business, we're going to gauge whether it's a substantial investment. And then you need to have at least 50% equity, okay? So therefore, depending on the amount of money that's required to satisfy the substantial investment, and whether you have 50 or 70 or 100%, is going to depend on how much money you have to demonstrate that you've invested.
And this is before getting in though, right? Before they actually give you...
Correct, okay? And the E2 visa requires that the investment be made ahead of time. So it's not, I'm coming to the US to invest. The visa is for people who have invested or are in the process of investing. That's how it works. So, the way I work with clients on setting up a transaction that makes sense, because the question is, well, why would I make an investment in an enterprise if I'm not guaranteed that I can go in? Well, usually the way it's done, if it's a purchase of an enterprise, it can be done through contingency in the contract. So the seller agrees with the buyer that if all the conditions in the contract are met, then the contract will close unless the person doesn't get the visa. So basically all the conditions are met, there's money in escrow, person goes, applies for the visa, they don't get it, deal over. Now there may be some, this is negotiating, right? So the seller may say, well, if I'm going to subject myself to the whims of a consular officer, I want to have some type of reward, right? So they may say, okay, I'll agree to that, but if you don't get the visa, you don't get all your money back, I may get it, so those are different ways. If you're starting, if it's a startup, then usually what you want to do is you want to start setting up the business in a way that you can document the investments that you've made. So, for example, you may agree to a lease, okay? But in the lease, you could have the same type of agreement as in the purchase, right? The lease is automatically void if I don't get my visa. But if I get my visa, I've committed to make this much payments in rent. And then I have to show I have that money, right? So as you can see, it doesn't really fit the entrepreneur model well. Why? Because what happens with most entrepreneurs, and correct me if I'm wrong, you will start with partial ownership or full ownership of an idea, and maybe you incorporate in order to develop and get patents and trademarks and so forth. But at some point, for you to get to where you want to go, you're going to need an investor. And usually and then even as you get investors, if it starts working, then you want to attract talent. And when you want to attract talent, and you're a small company, and you can't pay them what a competitor would pay them, a lot of times you say, I'll give you a share. And if we do what we're going to do, you're going to do very well. And the person is a dreamer, you know, they got that entrepreneurial spirit, so they'll say, fine, I'll take less money working for you, but I'm gonna get a share of the company. So in a short amount of time, an entrepreneur who has a thriving young business could find themselves from 100% or 50% to 25%, 10% ownership. So what happens in that situation? If you're on an E2 visa, you no longer have 50% ownership. So there's limitations to that visa. Another visa that's used a lot, that's listed here for entrepreneurs is, let me see, it's the L1 intracompany transfer, okay? So how does that work? Basically the idea there is if you have Siemens or some big multinational company, and that company has talent abroad, and they're doing business in the US, and they want to transfer either someone with specialized knowledge or a manager and an executive. You've done really well for us in European sales. We want you to go to the US and do the same thing. Okay? In that situation, you need an affiliate company or a subsidiary. So there's a foreign company that either owns the US company or vice versa, or there's an affiliate relationship, meaning there's common ownership. Okay? Pretty much the same people who own this company own this company. Okay? So in that situation, you need the appropriate relationship, and then they're looking at money, they're not looking at the idea, they're not looking at how successful you may be, they're looking at what it is that you're going to be doing here. Are you going to be engaging in specialized knowledge, and why you as opposed to somebody from the US? Well, this product was developed in Portugal, and we got to bring it in here to the US, and there's nobody in the US who has the skill because we started all this in Portugal. Or, hey, this is an executive level position, and this person has the experience with our company and we want to transfer them. So you can see just by my description that there may be some situations where I can take an entrepreneur and fit them in that model, but it's not easy, right? Especially if that person will at some point disassociate with the foreign affiliate. So outside of big corporations where I can use an L1 visa is a situation where an entrepreneur began a company abroad. They have ownership in that company. They're starting a company in the US. They have ownership in that company. If they have enough ownership where they would control it, 50% or more, or through voting rights or things like that, you can show that you can document the company, then there will be a qualified relationship, okay? But most entrepreneurs, once they get this puppy going, and they start this one, they want to sell that. And they want to make a profit. So what happens when they do that? They no longer have the qualifying relationship. Okay? So a tool that I used to use a lot with entrepreneurs is what's called the H-1B visa. And I mentioned it, it's listed there. H-1B visa says an employee is being hired in the US by a US employer, and that employee is a specialist. A specialist is defined as a position that requires as minimum entry into the position. In other words, you can't get into that industry without a college degree, and the person has the degree, and the person's coming to do that. So a perfect example would be a doctor, right? Or an engineer. So they come into the US, they have the education and the licenses to be an engineer or doctor, and they're coming to work for a hospital or engineering firm. However, I can bring that same doctor and that same engineer to work at McDonald's. It doesn't work. He's a specialist, but the job isn't, okay? Now, there's a quota for that visa. It's about $65,000 per year, which in the last few years, Usually you can apply 6 months ahead of the government fiscal year, and in the first week of that window, they're gone. So they're hard to get, number one. And second, it can be difficult for an entrepreneur to fit that. Why? Because even if you're highly educated and what you're doing is really specialist, the job that you're coming to do in setting up the business, it's really hard to define. And so it would be hard to even define what it is. Now, but there are circumstances where you can, right? And so what I would do is I would create a company. I would create a company and get an IRS tax ID number, and they became a US employer. And that company was owned by the entrepreneur. And then the entrepreneur, the company would petition for the entrepreneur would come in as an employee of the company. Well, a few years back, the Immigration Services issued a regulation saying, nah, that's not gonna work. And so,
It's
although
too
it
easy.
had been done, and I wasn't the only one who did it, but it wasn't super common practice, but it was a creative way of helping, you know, entrepreneurs who were starting a business. And they said, no, now the person who owns, you know, the employee has to really be subject to that employer. And if you're the owner of the company, then you're not really unemployed. They're not going to fire you, you know. So that eliminated that avenue. Okay. So another category that sometimes can be used is what they call the O visa, and it's listed there as extraordinary ability workers. Okay. But that's a very limited category. You know, if you could demonstrate you have extraordinary ability in entertainment, business, athletics, or science, then you could qualify. Well, I would have a lot of people who either they're applying science to a business activity, or business itself. They had established a company before, and they had done very, very well, you know, Zappos or something like that, and I'm now saying, hey, I want to come to the US and I want to start a new company there. Difficult, you know, but some very special people could be qualified under that, okay? So,
Is there a quota on that one as well?
no.
There's no quota on that.
quota.
Mhm.
We okay with time, or?
Yeah, okay. Besides the H-1B, there are other visas where there is a quota, or that's the only one where there is a quota?
There are others that have a quota, but they're not really applicable to entrepreneurs.
Okay.
So there's like temporary workers, seasonal workers, agricultural workers. Those visas have limits. You know, another visa that is used with entrepreneurs is the TN, Trade NAFTA, but that's limited to Canadians and Mexicans. And basically there's a schedule of professions. And if you meet that profession and you come in to do that profession here, then you can come under that.
Is it not announced a new one a couple of weeks ago for startups for 6 months or something?
Yeah, I mentioned that, we're gonna talk about that in a minute. It's not quite a visa, okay? It's not a visa.
Work permit or something.
Yeah, and we'll get to the details. And when I started talking about the difference between a visa and being admitted. And the reason I did that is so that you understand what this rule really does.
Okay, cool.
All right. So the TN, you know, again, it's limited to nationals of Mexico or Canada. And there's also the
Can I get one?
sure the E3, okay, which is kind of like an H-1B. That may not be listed there.
Yeah, I don't see that. Yeah.
It's kind of like an H-1B for citizens of Australia, and they have a quota, but they haven't reached the quota.
Okay.
So if I have someone who can come with an H-1B, but there's not a quota, like for example, I had a client from Ireland, and there wasn't enough visa numbers. I came to find out that he was a dual national of Ireland and Australia. So the same application through the Australian embassy, he got a visa to come in. Okay? And he was an entrepreneur, but he had been on an E2, okay? And this is a good example of how, under the current system, we sometimes have to play it. He came on an E2. He developed the company as a distributorship of a company in the UK. And they sell technology equipment for gyms, like heart monitors and, and all this computer stuff. And he's done very well. The company in the UK said, we want to do business in the US. We either do business in the US or we buy you. Which one do you want? So he says, fine, I'll sell, right? So he sells to the parent company, and they want, obviously the idea is to keep him running the company. But what's happened? He's no longer owner of the company, so he can't do an E2. You see? But the company is now being bought by somebody else, that's not him, and he's like chief operating officer of the company, which as a minimum, you need a college degree to do that job. So there weren't H-1Bs available, but he had dual citizenship with Australia, so he got that visa to come in. So that's one example of an entrepreneur who has used these visas that don't fit perfectly into that, okay? So in that background, it's Dieter. Yeah. As Dieter mentioned, the government almost 2 weeks ago published a rule, okay, in the Federal Register. Federal Register is the book the government publishes all regulations. And regulations are rules that the government puts forth to manage their duties under the law. So in the US there would be a law, right? But the laws tend to be vague, right? Very general. And so the agency has to say, well, we think that law means this. And they do that by way of regulation, okay? Well, there's a law in the United States that says that the government can allow a foreign individual to be paroled into the United States if it would be of a substantial benefit to the country. Now, what's parole? Remember we talked about being admitted with a visa? Well, when you're admitted, you're given status. Parole is when there's no status that you meet, but you can provide a substantial benefit, okay? An example of parole recently in the US has been for children of illegal immigrants who came here illegally when they were kids, and they've been given parole so that they can go to college. They don't have a permanent status, right? They haven't been admitted into anything. So remember we talked about non-immigrants? The other are immigrants, people who have a green card, and then they're citizens, right? So somebody who's paroled is none of those. He's not a non-immigrant, he doesn't have status, he's not an immigrant, and he's not a citizen, okay? So what this new rule says, we're going to parole these certain individuals, and it defines them as entrepreneurs of startup entities whose entry into the United States would provide a significant public benefit through the substantial and demonstrated potential for rapid business growth and job creation. Okay? Such potential would be indicated by things like the receipt of significant capital investment from U.S. investors. Now, we're going to talk in a second there's criteria for those U.S. investors.
And what is significant? Is it $1 billion or $5
Right,
billion?
and we're going to talk about there's specific there. Or obtaining significant awards or grants from certain federal, state, or local entities. And there's conditions for that too. The parole is intended to be for a 2-year period, and the idea is that it would be renewable once under certain circumstances for 3 years. So it would be a maximum of 5 years. So the idea would be in those 5 years, you better develop the business to the point where you can fit one of these categories, or hopefully there would be some legislation that would provide an avenue that fits entrepreneurs better, okay? So, these are some of the comments that I found, interesting. I think, first of all, a proposed rule is just the beginning of the process. So there's a comment, and then after comments, they usually come out with what's called an interim rule. And an interim rule, it goes into effect, so you can start doing things under the rule. Right now, it's just proposed, it has no effect. But there's still comments and it could still change, and then it becomes a final rule, and then once it becomes a final rule, those are the terms. So at this stage, all of this could change, okay? Now, but the reality is that when you have a proposed rule, if it makes it to a final rule, most of it, stays the same. But there may be some changes, okay? But one thing they say in the rule is that in all cases, whether to parole a particular individual would be a discretionary determination, okay? So what that means is that, for example, if I apply for an H-1B visa, and I meet the criteria for an H-1B visa, under the law, they have to give me the visa. On a parole, when it's discretionary, even if I meet the threshold criteria, they could always say no, okay? Now,
Do you need a sponsor or something for this?
I'm sorry?
Are they talking about a sponsor for this parole visa?
Not a sponsor, but we're going to talk in a second here about the criteria that you have to meet for them to consider you. Now, the government believes that this proposal is going to encourage foreign entrepreneurs to come and create startup entities with high growth potential. Okay.
This is what we are looking for here.
Yeah, and which
Hold
are
on.
and which are expected to facilitate research and development in the country that would lead to the creation of jobs.
I don't want to do.
Sure.
So, as you know, we are talking to many international companies at the moment, Munich and Austria and Switzerland. Would it be possible, so if we gather most of the interested ones sometimes, and you talk special about this one, maybe H-1B, make
Sure,
a special session over Skype to them, and
Anytime.
we try to get them in, whatever.
Anytime.
Yeah, that would be great.
Sure.
Because
We are,
it's
we
so
are
new
streaming.
now.
We are streaming this one too, but they cannot ask questions. But over,
No,
over
because
Skype,
it was
they
a
could
little short notice, but I would
Yeah.
like to get, all
Yeah.
our companies we are talking
Yeah,
to,
yeah.
because it's
I-
pretty new.
Sure.
I got already some email, what is that, what does it mean, can we come over, did we get a green card, all this, and we say we can't give you any legal advice, we have our partner.
Yeah.
No, yeah, that's actually a good question.
And
If this one actually becomes a rule, is there a possibility to change status? Because you said from some visas you may not be able to.
now, this is not status, all right?
That's
So-
what I'm saying. This is not a status. So,
now
is there a possibility?
So, there may be a possibility to apply. I didn't see that here. They talk about people who have the first parole, and when I get the parole extended, they're not going to require you to leave as long as you apply for extension of the parole before the first parole expires. Okay.
Or maybe, whatever, company comes to the Rocket Lounge, and we show that potential, we get investment, blah, 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 he gets this, and then during the time when he's developing his real company here, maybe then he can apply for an E2 visa. Or do we have to leave the country and come back again?
Well, if he's paroled under this program, he probably, unless that changes, or they address that in the rulemaking, they would have to leave to apply for a visa to come back. But they could do that. That wouldn't be impossible. Okay, so to be considered for parole, this is what they're going to look at. One, formation of a new startup entity. Okay, so they propose that the entity will be generally considered new if it was created within 3 years from the filing of the application. Okay, so at the time you file, it's less than 3 years old. Okay.
Created here. If they're
Yes.
already 10 years a German company, it's based on the US founding entity.
Correct. And
So if a
Right.
successful German entrepreneur wants to move over here and start his business here, we form an LLC with him.
well, okay. And we're going to get to, there's going to be some limitations on how you got that done when you're looking at not only a foreign entrepreneur, but a foreign entrepreneur backed up by foreign investment. That there's going to be some challenges with this rule on that situation. But you'll see what I'm talking about. And again, it's an evolving thing. It's only 2 weeks.
2 weeks, yeah.
And
But good, I
and
mean, some movement.
Right, and it's only a proposed rule, so things can change. Now, so, the other criteria is the applicant has to be an entrepreneur, okay? So they say that you should be able to meet this standard if you can show that the person possesses a significant ownership interest that they're defining as 15%, so 1/5.
1/5.
Okay, so if you possess at least 15% ownership in the entity at the time that you're applying for the initial grant, and have an active and central role in the operations and future growth of the entity, so that your knowledge, skills, or experience would substantially assist the U.S. entity in accomplishing the objective, okay? Now, let's talk a little bit about, before we move to the other, they have some interesting comments on what is a,
And the comments are coming from who? Lawmakers or coming from general
okay.
public?
What happens is that when they propose a rule, they have to explain why they're doing this, okay? And so, this rule is about, or this Federal Register notice is about 40 pages long. The rule itself is about 5 pages long. So there's 35 pages of procedural explanations and comments, but they're very useful because they give you an idea of what the agency is anticipating where they start applying that criteria listed, on the rule, okay? So when they're talking about formation of a startup entity, okay, this is some of the more in-depth things, okay? Again, they're looking for a company, an entity that has a substantial potential to rapidly increase revenue and create jobs. And that you should be able to show this by, since the date of the formation, the company has been doing business for any period, okay? So the question is, what is doing business, What's doing business? Now, the E2 visa has that criteria too. It says you have to be doing business in the US. Or, I'm sorry, in the L1. So it's very possible when the law talks about one term and then they use another, they shouldn't conflict. So doing business will generally mean that you have engaging contracts or manufacturing a product or providing a service and those type of things. But it says during any period of operation since its formation. So, you can get that done pretty quickly. You could incorporate, you could set up a business, and if you have the structure to start doing business, that's good news.
Sorry to catch up with
Yeah.
you. When it says in the formation, does it matter if it's abroad or if it's in the US? Does it state, could it be formed, say, in Germany?
No, it has to be formed here. It has
So they have to first come here, then be established, and that would count towards the formation period, and then from there that would count towards your evaluation for this parolee.
Correct.
Okay.
Which is already a conflict because
They have to come
if
to
you're
the
coming
mainland
here
first.
and
They
you
actually
have
don't
a
need to be
visa,
here
it's a
for
tourist
this.
visa, you're not allowed to
The L1
do business as I
Yes,
understand.
right.
Okay, well,
You can do business
But
trips. and
just to create an
okay,
entity,
but
you
that's
don't
not,
need to be
okay,
here.
that's not 100% accurate, although the spirit of it is. In other words, if I'm a foreign national, I come to the United States, and I start a business, I'm not supposed to be employed by that business, because I don't have employment authorization or status that would allow me to do that. But there's nothing that says I can't start a business, and that business can do business, as long as I'm not.
So we have a good example. We are just starting a company here together with a German company, which is already established. So we formed an LLC. Rocket Lounge has 35%, they have 65%. We're starting a business. It's a guy who has a house in Cape Coral. So we started now and engage customers and start to show it. And then maybe 6 months later, when we are fortunate enough to have customers and blah, 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 you can maybe apply for this kind of.
Sure, and under the B1 visitor, there's some provision for you taking the steps of prospecting a business opportunity, and So there's some flexibility
Yeah, you
there.
can do meetings,
But-
you can,
So, but you're correct that an
you don't
individual,
have to
an indi-
create income, that's
Right.
not allowed.
an individual could not come to the US and start doing business. But a corporation is a separate legal entity from the foreign national. So if you start a corporation, there's ways to start doing business without the foreign national falling outside of that, okay? Now, recently formed, again, 3 years. Now, they define a US business entity. So what is a US business entity? And they define as a corporation, limited liability company, partnership, or any other entity that's organized under federal or state laws, which is a very flexible definition and will cover just about every situation other than a sole proprietorship, you know.
Very broad.
It excludes a business that's involved in like securities and investments, and so basically they don't want an entity to be using money to go through that entity, or an entity that's really just not creating something, but it's really a financial,
Goldman Sachs or something like that,
yeah,
an investment firm.
you know, maybe like Bitcoin or something.
Yeah.
You know what I mean? But
Perfect. Sorry.
So this is the comment that they make in trying to define, in trying to explain what I just read. They say, a startup entity receiving capital under this proposed rule should not be serving as a conduit for reinvestment, but providing or seeking to provide goods and services that have the, again, substantial potential of rapid growth and job creation.
Plus, I mean, those would be anyway falling under additional rules and permits and everything.
Right.
If you would do,
Right, I mean,
investment, reinvestment,
you're
yeah.
subject to security laws. and-
Exactly, so SEC would be involved, and then, that's a
Right.
whole different other area.
Now, the entity must be of a type so you have to demonstrate to them the substantial potential to experience rapid growth and job creation. And they say that basically the reason they're putting that potential in there is they're saying we're trying to limit it, or we're trying to exclude small businesses that would generally basically just provide for income for the owner and his family,
Okay.
okay? So they wanted to be a bigger thing. I personally have a problem with that, because in this country, most of the economy is driven by very small companies. And you can have an entrepreneur who has a very small company that perhaps is not creating a lot of jobs directly, but can have an impact on your community and
So
providing
for
you
example,
service.
if you want to create an ice cream parlor, then that would be probably not under this rule.
Right, but, right, so those are some of the restrictions that they're putting to that definition of the startup entity, okay? So then we also talked about the applicant has to be an entrepreneur. So how do you define an entrepreneur? So they say that to demonstrate that you're an entrepreneur, you have to show that, again, you possess a substantial ownership in the startup entity, which we said was 15%, and have that active role and knowledge, ability, and so forth. Okay? So you're gonna need 15%. In the renewal stage, the entrepreneur will still meet the definition if they maintain 10%. So it's less. And they say, we recognize that entrepreneurs may possess larger equity stakes in the startup entity at the time of formation, but it may reduce, as we talked about that
Yes.
earlier. And that's very normal, okay? It says they also recognize that a startup is not limited to one entrepreneur. So you can have more than one, but you can't have more than 3 per entity, okay? So you could
To
have,
be paroled.
3 individuals per
So
role,
a team could
3 individuals
start
per
a
role,
team, come over.
and under entrepreneurs, but they would have to meet the definition. So you'd have to have, between them, at least 45% ownership, because each would have to have 15. But
So then individually, they still have to have 15.
Yes, individually they can.
As a format.
Yeah, yeah.
Now, they're saying, in addition to that, there may be circumstances under which you can provide additional documentation as to the person's role, okay? And they say that some of the documentation could be letters from relevant government agencies, qualified investors, establishing the business associations, and speaking to the knowledge, skill, and experience of the person. Newspaper articles or similar evidence that the person has been, so what are we talking about here? We're talking about someone who doesn't quite rise to the level of a O1, remember? He didn't start Zappos, but he started something significant, and there's some press out there, but he's not gonna meet that criteria for an O1. Evidence that the applicant or entity has been invited to participate or are participating or has graduated from an established or reputable startup accelerator. Okay. So that's, you know,
Accelerator.
yeah.
Or
You
graduation.
know what I'm thinking of?
Yeah, we have
That
to
we
do
are
an
providing
official-
certificate of the incubator as well as the accelerator. So that could be an evidence.
we have to be accredited, that we are an accredited accelerator and incubator here.
Well, who is the accrediting?
I don't know, maybe there's an institution from the federal to say you are an accredited accelerator, I don't know.
Yeah.
That's very loose.
There are 500 accelerators in San Francisco, you think?
Now, I don't recall, but I don't think that they went to that level of defining what a established and reputable startup accelerator is. But they may
Well, it's
have,
not certified.
they
It's
may have or may not.
reputable. So
Yeah, it says,
you know there are a zillion articles about us. So that could
Yeah.
mean we are reputable.
We have to
And-
make a nice.
Yeah.
yeah, and it doesn't have to be graduation, it says invited to participate, or is currently participating, or graduated. So let's say, so the idea would be this, the idea would be that, remember,
Walpole, when you
Yeah.
say you only can get the visa if you have graduated from an accelerator, that's interesting.
Well, it's not a visa.
it's a parole,
parole.
but the idea is that, remember, it's in the context of 3 years. So they're saying if you're gonna be considered a new startup for purpose of the parole, you have to have been created within 3 years.
We have to have this passage from the text.
So,
yeah.
so within the 3 years, right, then you could have those people. Somebody who just started the company and they're, you know, they're in your incubator, but you invite them to the accelerator.
Yeah.
Or they could be somebody who has moved to that stage, like you were describing to me before, scaling, right? So
Yeah.
they gotta go into the accelerator. Or they may have graduated, and they may not even be here anymore. But they come to you and they say, hey, a year ago, I was in your organization, and you would be able to give them something, you know,
Yeah.
to facilitate that, okay?
Mhm.
All right. Okay, and then they would just look probably at, you know, the general stuff, you know, the qualifications of the individual, degrees, you know, certificates, you know, in computers, you know, we completed this, okay? All right, so those are the first two, right? So new startup and an entrepreneur. The third one is you have to have a capital investment or government funding, okay? So they say that you can demonstrate that by showing that you have received substantial investment of capital from U.S. investors with established records of successful investments, and they define what that is, or received substantial awards or grants for purposes of economic development research and development or job creation from federal, state, local government entities. So for example, if you have someone who is doing something locally and the Lee County Development, Economic Development Office is helping them, I
We
think,
just sat in here this morning and talked about this.
I think that'll work, okay?
Yeah.
Okay, so those are the two ways. Now they say, alternatively, for those people who meet one or more of the criteria, or they meet one, but the other one they quite don't meet it, and we'll talk about what that means in a second, they can provide additional evidence that could, that they will take into account, okay? Now they say that even if you meet the investment or funding criteria, they're also going to look for you to provide supplementary stuff, such as, so remember, when I talked, there's threshold criteria, but this is a discretionary benefit. So what they're, in legal language, what they're saying is, the threshold criteria is the amount of, the investment, either from a U.S. investor, reputable and established, or federal or state. But that's the threshold. They're basically saying, but in addition to that, for discretion reasons, we're gonna wanna see other stuff, okay? And so they talk about receiving additional funding from a government entity, being accepted into a startup accelerator, generating significant revenue or creating jobs, creating new technologies or engaging in cutting-edge research, or demonstrating that the entrepreneurs, his skills and so forth would really substantially advance the business. So that, that situation is like, okay, we have the funding, but without this person, the funding is worthless, right? Okay.
So it's a quasi O1
Yeah.
in a startup environment.
Yeah. But the O1 is a really high level.
No, I understand that. That's why it's a
Yeah.
quasi, because it's an extraordinary for that particular
Correct.
startup
Correct.
skill. Yeah.
Now, no, the substantial investment from a qualified U.S. investor, this is what they say, they're proposing that substantial is going to be if at the time of initial application, there have been investments that from one or more qualified U.S. investors that meet or exceed $345,000. Okay, so you need at least $345,000.
Invested.
Yeah, invested.
Okay.
Yeah, from a U.S. investor, and they say, basically they say that they think this figure, reflects what is normal in terms of angel investors and things like that.
Angel, yes, but VCs, it's much bigger.
Yeah.
Yeah, but at the same time, there are
I
certain
think when they
angel
talk
investments
qualified-
which are much
I
smaller
think when
than
they
that.
talk about qualified, they mean accredited.
Yeah.
How you qualify an angel
I
investor.
mean, at the same time, it's a pretty sizable amount. I mean, some of the
Angel.
angel investments are significantly lower. It starts from 50,000 up.
Yeah.
So
There's specific languages. The Department of Homeland Security reached this figure after analyzing available data on angel investments, the largest source of startup capital for innovative firms, as well as initial or seed round investments.
so
from
they basically
venture-
created an average.
from venture.
Out of those.
Yeah, of course,
Yeah.
it's 345 years in Florida, it's a lot, in New York and San Francisco.
Oh, yeah.
It's nothing. Yeah.
True.
Yeah.
It's nothing.
Yeah.
But that's why it's good, because probably the data is coming from these Palo Alto and New York and Boston,
Yeah.
and therefore the whole figure is good, because here in Florida, that's already a very substantial amount.
Yeah.
Right.
There, it's like, what, it's a drop in the ocean.
Yeah, true, of course. I mean,
Yeah.
go to Silicon Valley.
Yeah, I think 345 is still.
345
Yeah.
is not chunk change.
And they
but it's-
and they have a footnote where they
Yeah.
address all that.
Yeah,
they say,
sure.
hey, we're aware that there's a wide range of investment amounts.
There you go.
But at some point we had to pick a number, so
Yeah.
we picked one.
Okay,
Yeah.
so
Okay.
that's just a basic baseline.
Yeah. So let's see. So yeah, so it would be 345. Okay, so as far as a qualifying investor, they're looking at investors who have a history of making similar or greater investments on a regular basis over the last 5 years, and who can demonstrate that at least 2 of the entities receiving such investments have subsequently experienced significant growth, okay? So,
Track record for angel groups.
so,
Basically, Shark Tank.
and they explain this here, okay, they say, so they're proposing to limit the qualifying investors to those who have, the established record. Such a record would include, although it doesn't say require, it says would include, that during the 5-year period prior to the filing of the application, one or more investments in at least 3 separate calendar years in exchange for equity or convertible debt. So they're gonna have some, some established. Now, the one thing they make a point is that they're gonna require monetary commitments. They're not gonna accept non-monetary commitments, as in, an investment in intellectual help in developing something, in exchange for.
Cash is king.
Yeah. Okay, the investment cannot come from the entrepreneur himself, or parent, spouse, or brothers and sisters, family, or a company, partnership, or other entity in which the entrepreneur or the family are directly, they have a direct owner, or direct or indirect ownership interest. Okay. And then the substantial investment has to have been received within 365 days of immediately preceding the filing of the application for initial parole. And that's one thing that I'm going to be interested in either looking at it more closely or just figuring out what they're saying, because they're saying, hey, if you were started up to 3 years ago, but the investment, the angel or seed investment has to be less than a year old, then that starts to limit the 3-year people.
Is it public available now, the information?
Oh yeah, it's in the Federal Register.
Yeah.
Now, substantial government awards. You could satisfy this by showing awards or grants by one or more federal, state, or local entities that regularly provide such funding to U.S. businesses for economic development. So SCORE, maybe, something like that. Economic Development Office.
SBDC.
Yeah. Now, they propose to exclude any contractual commitment for goods or services, including contracts that may appear to be or could be made to look like an award or grant. Okay? So they're saying, hey, if we think you really did a lot of gymnastics to make this come through the government, we're not. But again, those are. But anyhow, they propose that to be considered substantial, such awards would need to total 100,000 or more. Okay. So, for example, or specifically, it says either an investment or a grant. It doesn't require both, right? So you could have a situation where somebody got 100,000 or more from a grant, but
And then that's how
but
it's
got an
done.
angel investment of 150,000. But then they said, alternatively, if you meet one or the other, we're going to look at the other stuff. Then that's how you get there. Okay. The renewal, the difference in the renewal process is they have some, in order to renew, then you have to have investments of up to 500,000.
As an
And you have to-
accumulated amount.
So that you see there's growth in this.
Yeah, and you have to demonstrate, I think they said 10 jobs. Or 5 jobs.
So that business which you are developing already have 5 to 10 employees.
Right, and I think they said 20% aggregate growth. So we're gonna look for that you obtain additional investment
If you want to renew the parole.
to renew. I'm going to be putting together like summary of it, you know, and I can share that with you, so that you can share it with.
Especially when we have foreign
with
companies.
your customers.
Foreign companies.
And obviously, when it becomes either an interim rule or a final rule, then at that point, but is there any questions?
Please go ahead, I'm just gonna ask something, Mina.
No, it's great.
Do you have the document number by any chance? I know it's on the Federal Register website, but the document itself, number or series or,
Yeah, it's volume 81, number 169.
okay, 169. No word on when it's going into effect.
Now,
right?
you know, as a practical matter, if you went to uscis.gov, which is the website for U.S.
Mhm.
Citizenship and Immigration Services, I think they have a section that's called News,
Okay,
and every time they publish something in the Federal Register, they put it there, and they provide a link.
Mm.
So that may be an easier way to find it than going to the Federal Register.
Okay. super.
Any other questions?
Please,
What-
Oops.
That's okay. What name did you say that was, I'm sorry?
Your website?
Yeah.
USCIS, that's United States Citizenship and Immigration Services, .gov.
Okay.
And then somewhere there's gotta be they have a section for news,
Mhm.
like new press
Like
releases.
if new things come in as well?
Like press releases.
Okay.
Anytime, you know, they do a press release. And I don't think this will be the most recent one, but if you scroll down, it's
And
relatively
I
recent.
think you asked the question, what do you think, how long it's gonna take until an interim or final rule this becomes?
Well, written comments must be received on or before October 17th.
Okay,
So, you know, I'd say probably by the end of the year,
it's gonna be an interim rule or a final rule?
no, an interim.
Interim rule. Mm-hmm.
Sometimes they go straight to final.
Mm-hmm.
Yeah.
Mm-hmm.
It does depend on a number of things, you know, there can be a challenge or something,
Yeah.
or sometimes, a comment, somebody will make a comment that will make them, rethink something, and then that would extend the period, because now they gotta
Yeah.
redo it, but generally, I would expect by the end of the year that.
It's gonna be at least
Or
interim.
early next year.
Mm-hmm. Okay. All right, great.
before I forget, sorry, denials, if by any chance somebody applies and gets denied, is there an appeal rule or an appeal process by any chance, or process?
You know, I didn't see that, but I'll tell you, generally, the answer is no, because it's a discretionary benefit,
Okay,
okay? But there's nothing that says you can't resubmit it.
okay, so basically you don't repeal that initial denial or submission, you basically just refile again, do you have to change name of companies, or do you have to
No,
just
no, no.
basically resubmit with all your new updated evidence or requirements?
Right, in other words, if you thought that you could overcome the reasons for denial,
Okay,
then you could submit, resubmit it.
okay,
I will tell you that there's been times when, this doesn't always work, and I don't recommend it as a process, but there's been times when I got a denial on a parole that I thought was just they just totally misunderstood something.
Mm.
And I've sent a letter right away saying, look at this again, and they've done it and approved it, but,
a bit of an exception and not a rule, I guess, one of those, okay.
I don't see.
I mean, no worries,
A good thing about it that I didn't mention is that employment authorization would be incidental to the parole.
okay,
So sometimes in the U.S. there are statuses or that entitle you to apply for employment authorization. So that means you get it. That doesn't mean you're employment authorized. You can apply for employment authorization. They're saying employment authorization would be incidental, means if you get it, you automatically.
Immediately, yeah,
Okay.
because without that you cannot do it.
Right.
What you get it for, yeah.
Yeah. So, but sometimes that happens where you get it and then you gotta apply for a
Yeah,
work
yeah.
permit that takes 90 days and that delays you by another 90 days. Now, what it does say is that spouses and children under 21 can come to the US with the person. There's
Spouses under 21 or the children?
spouses and children under 21. Yeah.
Good question.
Yeah.
But spouses will not get employment authorization incidental to the parole, but will be eligible to apply for employment authorization,
Okay.
which none of these except the L visa and the E visa allow for spouses to get work authorization, but the H-1B doesn't.
Yeah.
Except very limited circumstances. So that would be a good thing, because that really, that's one policy that has limited entrepreneurs in the US, is that, they may be able to fend for themselves, but in this country, there's few people who don't have two income families.
Yeah.
And so to ask immigrants to have a one income family, it's very difficult. So,
Special startups, they don't pay much.
yeah, so that's I didn't see anything on the procedure for that, if there's any, I don't think so. Another positive thing was they said that, in terminations, they're gonna try to send notices of termination.
Excellent, okay.
So if they felt that something changed and they wanted to terminate your status, let's say you stop working for the incubator or for the company, or you shut down or whatever, because under the law, termination's automatic.
Yeah.
So when something's automatic under the law, it means it happens whether you know about it or don't.
Kicks in immediately.
And the way they described termination there, they said it's automatic if you advise them that you've left. Well, in that case, then you're aware.
Yeah.
But otherwise, they're gonna try to, they say we intend to send notices.
They should have some kind of a grace period, so if you have to migrate back home, or if you're no longer eligible to stay or whatnot, you could give you some buffer time to transfer over, or to, execute that plan B elsewhere.
Yeah.
So you don't just receive that day, you're at work, or, you're at the coffee shop and you get that notice,
Yeah, the only visas that have that currently are student visas. You have a grace period to transition or just go enroll in another program or do something. And exchange visitors, which are J visas. And I don't think.
Oh, but H-1B, when you are coming over for a company and you leave the company, I think you also is termination.
Yeah, that's automatic.
Automatic.
That's automatic termination. If you're here on an H-1B and the company says, we don't want you anymore, you're out of status.
Basically, back
You have to leave and go, okay?
So stay here as a.
Yeah. So I have companies that employ H-1Bs, and then there's generally two situations, right? One, you're getting fired because you deserve it. The other, we're gonna let you go because business is slow. And in the first, they just terminate you. You're out of status. They don't care. On the other, they sometimes will keep you on payroll for a while to give you an opportunity to find another employer who could file a change of status. Those are very nice employers.
Yeah. Responsible employers, I would assume, you have that extra pocket of money in case when your guys go,
Yeah.
they have that buffer. It's not such a bad transition.
Great.
That's all.
Thank you much.
Yeah.
Excellent.